Welcome to the Case Autopsy, the Verdict and Settlement podcast. With your host, Mike Campbell. Case Autopsy is part of the family of podcasts brought to you by Lawyer Minds. In this podcast, we explore recent verdicts and settlements from around the country to try and distill down the best techniques for you to apply in your cases. Here's your host, Mike Campbell.
Tad, you tried a case.
It was nice to be back in the courtroom and not have to wait another year to get into trial.
Any true trial lawyer will tell you they are pining to get back in the courtroom. It's where they live, right?
Mm-hmm. I was talking to a lawyer, a friend of mine in Chicago today, and we were talking about how next year we're probably going to be living in the courtroom because so many trials are getting continued from this year. They're going to have to get tried sooner or later. So 2021 and 22 are going to be a lot of courtroom hours.
And you know what'll be interesting to see on the other side of that is all of the newer attorneys who get that sort of first, second chair experience coming on the other side of it. Hopefully there's like an army of new lawyers who are just really experienced because you don't really get many trials. So that's kind of an interesting thing. It's sort of like when you have a blackout and then 9 months later, people start having babies. It's a really weird analogy, but it's the only one that came to my head.
That's right. So true.
Babies and new lawyers. So man, let's back up. We'll talk about this trial in that you tried during COVID, which is you're one of the only people. I think there's another outfit that they try a ton of cases down in Southwest Missouri that they tried a case, but these things are not happening. And if they are happening, they're happening virtually. And so tell me about what your conversations were like with the judge leading up to the case and how you guys kind of walked through what you're going to do.
So, interestingly enough, so the way my office is set up, there's very few cases that are considered my cases that I work up. They're worked up by the other attorneys in the office, and I come in and take the lead on the trials typically. And so I come in at the last minute. And leading up to this trial, I knew this one was on the calendar, just like a lot of other ones. And I even didn't go to the final pretrial conference because I just assumed that, like every other final pretrial I've had in the last 3 months, they're going to reschedule the trial. So I didn't even go. And so I get a call from my attorney in Cincinnati who runs our Cincinnati office. It just had the pretrial. Judge says we're on. So there's 2 weeks before trial. So I got, geared up. It was a straightforward case. So, easy enough to get ready for in 2 weeks. And what was unique here was the chief judge in Montgomery County, Dayton, Ohio, had a standing order continuing all trials with exceptions. And the exception was if you get permission from your trial judge. Well, this judge, Judge O'Connell, thought we need to have a trial. So, leading up to it, even though the chief judge said continue all trials, he said we need to have one. And so he had one. And so immediately, I guess, the Friday or the Monday before trial, we started on Tuesday. Right before that, we got a sua sponte order from the court that was the COVID protocol. And it kind of went through and talked about what everyone's expectations were, what the jury would do, what the witnesses would do, and things like that. So, he had obviously already thought it out. And I'm sure the judges have been having calls, like all the attorneys have been having calls on how to try these cases. And so he had his protocol in advance of that.
So you try a lot of cases. You tried a couple successful ones to verdict last year, and then you had this trial. And so there are techniques that I want to dig in with you sometime about those compared to this. But this is such a novel thing that I want to talk a little bit about, your experience dealing with jurors. Were they wearing masks?
Yeah, they wore masks 100% of the time. And, in order to be able to do this and do it right, it requires the court staff to really take time and put in some extra work. And one of the things that they did in this trial was they called all of the jury pool before the trial, the week before, and informed the jurors as to what they were going to do to keep them safe, what the COVID protocols were. And then they would ask them, and we can talk about what all we did. But after they informed them of that, they asked them, "Are you comfortable serving?" And if that juror said no, they were excused.
Do you know how many? I'm sorry to interrupt. Do you know how many jurors they called, or how many that was agreed upon to call?
I don't, but I know we ended up with approximately 45 in our pool.
45 people showed up.
Correct.
Wow.
Yeah.
Okay.
So how many they had to call to get to the 45, that I don't know.
Right.
The other thing that they did was they also excused anybody who refused to wear a mask, which I thought was significant. They called them, if they said, no, it's my constitutional right not to wear a mask, I'm not wearing one in court, 24/7 for 8 hours a day while I'm sitting in the courtroom, those jurors were excused also.
Well, so when you're doing jury selection in a situation like that, well, did you handle jury selection? Or
I did, yeah.
You did? Okay. And who did you try the case with in Cincinnati?
Lou Snyder is,
Lou.
My attorney runs our Cincinnati office, and the defense lawyer, I was a well-known med-mal defense lawyer up there, Brant Poling from Columbus.
And this was a med-mal case.
It was. Mm-hmm.
And so obviously, not only are you trying a case during COVID, jurors don't want to necessarily be in the courtroom anyway, but during COVID, I'm guessing there's probably a heightened sensitivity to that. And then also there's a deference to doctors and nurses, and especially now because they're considered frontline heroes. So how did you approach that in jury selection?
It's for those of us that do med mal from the plaintiff's side, I think we recognize that, most jurors hold doctors and nurses and hospitals in high esteem anyway. I don't believe that the whole COVID and the issues that are going on now, maybe depends on the jurisdiction, but I don't believe it's much worse than it already is.
Sure.
Jurors hold doctors on a pedestal anyway, any other time of the year. So, and under any other circumstances. So you do, I did voir dire on that issue. I did, ask about, attitudes toward doctors. I asked about attitudes, in light of COVID, does it change? And, so we had discussions on that. And, we had jurors that were excused because they did hold doctors on a pedestal, but we actually had one juror excused because he specifically said he didn't like doctors and didn't trust doctors. He had obviously had a bad experience in his past.
Sure.
So in doing the voir dire, I didn't feel like the responses that I was getting was much different than doing a med mal trial a year ago before COVID ever hit.
That's really interesting. I think that's encouraging too for people who do med mal trials, right? I think one of the things that's concerning is the fact that these are people who already, like you said, held on a pedestal, but now during this time, the belief might be that they could get that extra deference. Mm-hmm. When you're doing jury selection, you're talking with the jurors, was there, and this wasn't your first rodeo, obviously.
Right.
So your
first COVID rodeo.
First COVID rodeo, but this is you're reading facial expressions, right? When you're talking with people.
That was very interesting. No, you're right. And that was one of the things I was always worried about is, how do you read facial expressions when someone's wearing a mask? And you'd be surprised once you're in there how much you can read. In their eye movement, raising eyebrows, body language, when the juror's in there and they're listening to a particular witness, slouching down, gazing away. Just because they had masks on, you could still read them, and you still had a pretty good idea who they liked and who they didn't. So that was a very interesting part of the trial.
Right.
It was a little harder during voir dire. because you could do it during the trial, and because there were fewer people to pay attention to. What was a little bit harder during voir dire is not picking up those subtle movements. So when you ask a question to juror A and a juror 2 seats down in normal times, you can see their facial movements and you can see their reaction and know that they're reacting positively or negatively to the question. That was a little bit harder.
And then you can do a follow-up, right?
Yeah, exactly.
Yeah.
So panning the jury, and the other problem is because they're socially distanced in the pool, so it's not like they're sitting right on top of each other and you can look in one direction and see everybody. We had 10 over here, and we had 15 in the back, and then we had 20 in another room even that were watching on video, and there's all this distance in between the jurors, so it was a little bit harder to get to everybody. So
let's explore that a little bit. Tell me about the layout. Was this in a courtroom? And if so, the size of the courtroom, what it looked like, and this remote room. Tell me about how all that worked together.
I'd say I'd call it a medium-sized courtroom. It was not a huge courtroom like a lot of the federal courts, where there's a ton of room. It was I'd say a medium-sized courtroom, but the way it was laid out, the judge's bench and the clerks took a ton of the well. And so there's not a lot of distance between us and defense counsel and us and the podium, and then the podium and the clerk. So that area was pretty compact.
This is like a new courtroom, rule courtroom?
It's older, probably built in the 70s.
Okay. Just to get a sense.
Right.
Yeah.
So in Ohio, you have 8 jurors and an alternate. And so we were able to add a couple seats into the jury box. So it was a little bit longer than what you would need for even 12. But then we added a couple seats in there that kind of came down even behind our table. So our 9 jurors were spaced out once the jury was set. They were spaced out, in the jury box and kind of behind us. So, the alternate was actually sitting directly behind me. So I kind of had to pay attention to what I had up on my laptop, knowing that they're sitting right behind you.
When you say they're sitting right behind you, were they in the viewing section, or were they up in the box?
They were essentially on our side of the bar, but then there was a row of seats behind counsel table, but on that side of the bar. So they weren't in the gallery per se.
Oh, that's tough. That's interesting.
Mm-hmm.
When you were talking about the remote room, were people in the remote room answering your questions?
No, the way the judge instructed us to do it is we did the voir dire just on the 25 in our room. And the idea was that if we got through the 25, with cause strikes, and we needed to start pulling in jurors from that other room, we could have done that. It worked out that, there weren't a whole lot of motions for cause, and we were able to pick our jury out of the 25 that were in that room. So they were instructed to watch and listen. If they had come into the other room, into our room, then they would have been asked some follow-up questions based on, what their responses would have been to our questions, but that wasn't necessary.
Wow. So is the judge striking jurors on the spot, I assume? So this isn't an issue. You don't have a conference at the end of jury selection, right?
He didn't. And that we did do it as a conference. So we did our voir dire out of the 25. Then we went back in the judge's chambers wearing masks the whole time we were in judge's chambers, and did our cause strikes first and then our peremptories from there. I think it was pretty obvious from our voir dire on both sides that we were going to get a pretty fair jury out of that 25. I think if it was an issue where we had too many cause strikes, and as I'm making notes on who's going to get struck for cause, we probably would have noticed if we were going to run into a problem, and we could have addressed it before we went back to make those motions. But the way that it worked out, we just did it after we closed our voir dire, went back and did our cause strikes.
When you're up doing jury selection, are you taking notes on like a grid or a piece of paper? Or you focus solely on asking the questions and hoping second chair's getting everything?
I would say for the most part, I expect my second chair to take
Mm.
most of the notes. I've done this enough times where, I kind of have my own little crib sheet. I know in my mind what a circle means and what a check mark means. And, I can make short notes on the grid so that I know, who to make strikes for cause for. And so usually, I'll write a C down when somebody, has an answer that I think I need to make a strike for cause. I don't necessarily write the reasons down. So when I see that, I make my quick, I ask my follow-up questions. And then when I go and I sit down, I'll make notes based on what I recall them saying, compare that with my co-counsel.
So there was something unique too about the way that they sat the jurors or the way that they struck them. There's some strategy involved, I think, on your end. Am I mistaken about that?
Yeah. And so, every state, it seems like, does jury selection a little bit differently, but the way that they do it in Ohio was, your first 8 jurors are, that's your jury. So they call in 45, they randomize that 45 and then seat them 1 through 45. The first 8 are your jury. Number 9 is your alternate. So if you strike number 2 for cause, number 9 becomes juror 2 and number 10 becomes the alternate. And then if you strike number 3 for a peremptory, then 10 now becomes juror 3 and 11 becomes an alternate. So who's coming in to your box, which causes you to have to really use some strategy as to, are you going to use your peremptories and how you're going to use them? Because if I strike juror 1, 2, and 3 because they're bad for me, well, I may end up with 15, 16, and 17, and they're worse. So you kind of have to think ahead as to how you're going to use those peremptories.
Sure, they just slide right down.
Mm-hmm.
So when you're given, did you do the opening statement? Was that
No, my co-counsel did opening. I did closing.
Were the jurors wearing masks the whole time?
Yeah, the jurors wore masks, even responding to questions in voir dire. The jurors never took their masks off, and they were really good. I watching them for the week, very rarely did you see them. They didn't let them kind of shrink down much. A couple of them did, but for the most part, the jurors were real good about wearing masks 100% of the time. And all the attorneys, you always wore a mask unless you were the attorney doing opening or closing or actually questioning a witness.
So when Lou got up to do his opening, he didn't have a mask on, and I
Right.
assume he got up. Was he able to walk around the well and talk to the jury, or was he required to sit at the counsel table?
The well was so small anyway. It didn't, I like to walk when I do my openings and closings as well.
As do I.
Yeah. And the well was so small, you really didn't have that opportunity anyway. So the way that, the clerk's bench sat, where our desk sat, and where the podium was, there wasn't a lot of walking and moving around. If you had gone out in front of the podium, you would have been within 2 feet of the juror, and I didn't ever want to do that. I didn't want to be on, you don't want to be on top of them anyway, much less during COVID.
Yeah.
So I walked a lot less during that case than I normally would.
Did that hamper any of your presentation style?
Not for me, and
Okay.
not really. It was a little bit different, but it's most federal courts that I've been in, those judges don't let you leave the podium anyway.
Right.
State court, they're more relaxed about that. So I'm used to doing both.
Understood. Did you guys, when you went up and had conferences with the judge, I assume everyone has masks on?
Yeah. And so if you're the attorney asking the director cross questions and it's your question that was objected to, you had to remember to have your mask in your pocket or grab it from the podium before you went to talk to the judge. But yeah, we actually did bench conferences. The way that the courtroom sat, he could do the bench conferences just on the opposite side of the bench than what the jury was. And yeah, we always did those with with masks on, which, makes it a lot harder for the jury to read your lips and know who won or lost an objection.
But the other thing too is it never fails that when I'm trying a case and we have to go up to the bench, the court reporter's always leaning in and saying, could you repeat that? Could you repeat that? And with masks on, I don't know if they have better technology in some cases.
So in these courtrooms, we don't have a court reporter. In Dayton, it's all video.
Okay.
So you talk into the microphone, and the camera picks up that microphone.
Okay.
So you could essentially just whisper in front of the judge, and that mic would still theoretically pick it up. I haven't looked at the video from trial to see if it always did that. I'm sure there were probably more issues than you would normally have. But it's not like a court reporter taking everything down. It's all recorded.
One of the other interesting things that I picked up on in this trial was that you submitted the case to the jury on a Friday afternoon around what time?
Yeah, that was not my preference. Yeah, we can talk about defense lawyer strategy. We didn't close until after lunch, so I don't think the jury got the case until 3:00.
But they still they went back and deliberated, right? They went past 5.
Yeah. Well, no, because they weren't out long. It was a tough case.
Okay. Well, I was trying to give you some credit, man. I'm like,
don't give me credit on this one. I did the best I could with the facts I had.
But med-mal, COVID, giving the jury the case at 3:00 on a Friday afternoon after being there for 3 days.
I got 2 out of the 8. So
you know what, man? Does it have to be unanimous? Does it?
No.
Does it be 8-0 or 6-2?
6. You got to get 6 of 8. And the jury didn't deliberate in the jury room. They deliberated in the courtroom. So
that's cool.
After closings, the jury left. They split them up into two rooms where they could take their breaks. All the attorneys packed up and went out in the hall. The jury came back in to do their deliberations in the courtroom so that they could socially distance.
Backup presentation of evidence, witnesses, expert doctors. Are they wearing masks on the stand?
They wore masks to the stand and off the stand, but the witness stand was behind plexiglass.
Oh,
so
cool.
They had a couple, not floor to ceiling, but had the bench, and then you had the 3 or 4 foot tall plexiglass that you see a lot of places now around the witness stand. So it wasn't so bad that the jury couldn't hear, but there was social distancing. They had that, but the witnesses did take masks off to answer questions.
What advice would you give to anyone else? And that's a pretty big question, but what advice would you have for anyone else who might be thinking about going to trial or have a trial set during this time?
I think we as plaintiffs lawyers need to be pushing for these trials. We can't just wait until 2021 to try every case. Would I try every case, that comes up in the next 6 months? No, I don't think it's appropriate for every case. There are certainly cases that I don't want to try in the middle of COVID. For me, the shorter the better. I try to trim down my trials to begin with. I think if you're going to have a 3 or 4 week trial, I probably wouldn't do that in the middle of COVID. I think that adds a different dynamic. I felt like 4 days in the courtroom was enough for this jury. So I wouldn't do every case this way. I would, I think we as lawyers and the judges need to look at, the technology solutions that COVID has forced upon the judicial system, taking remote depositions. If you can swear a witness and take a remote deposition, there's no reason why you can't swear a witness and do remote direct testimony on a witness stand in a trial. Now, are there witnesses you want to come live, for various reasons because they're key witnesses? Yeah, absolutely. But, every trial has witnesses that are kind of B-roll players.
Sure.
That you have to get the information in. But they're not critical. And, the judges need to be allowing us to call these witnesses remotely. and the jury appreciates it. And, and doing a remote testimony is even better than, doing a videotaped testimony. So, I guess, one of the main reasons I tried it, and, I took notes every day of what we did, and I wrote it up and I've shared it widely, if we have to be pushing to get trials done. It's a disservice to the entire system and the litigants in the system to just bump all these trials for a year without even trying. In Chicago, can we run 20 trials at the same time in the same building? No, you can't do that. Sure. But, in some of the rural counties around Kentucky, can the clerk pick up the phone and call jurors and say, here's what we're going to do. Are you willing to come in and get a fair jury? Yeah, that can be done a lot of places. And so maybe you try 2 cases a day in Chicago instead of 20 cases, or,
right.
The same in Louisville. But, the system's ground to a halt, and until we got to get the wheels moving again.
And, I know that people who are listening to this probably already know how to get into contact with you, but I also know you're one of those people who will share as much information as you have and can with anyone. If someone wants to reach out to you, what's the best way to get a hold of you?
Yeah, the best way is email. Just tad@thomaslawoffices.com. Shoot me an email. I've talked to a lot of people this week. A friend of mine's trying a case in California here in a couple of weeks, hopefully. There's another lawyer here in Louisville that's trying a Dayton case in a few weeks. And, he called me up to talk about our process. And, I've written up how we did it. I think we did it safely. There are a few things that I probably would have even added to make it even safer. But, I'm confident in the process. I think we had a good, fair jury. Did it come out the way that I had hoped? No. Did they listen to the evidence and pay attention? And were they fair? I thought they were. And, so yeah, I'm happy to help anyway, give anybody any information that I can to help them get these cases to trial.
Awesome. Thank you for your time today, Tad. And thanks for going out there and doing this for us and then talking to us about the outcome.
Thanks for having me, Mike.
All right, man.
That concludes another episode of Case Autopsy, the Verdict and Settlement podcast, part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.